Hello everyone. In this presentation, the remedies available for a breach of contract are explained. Rights and obligations are created by a contract. When rights are created, a mechanism of redressal has to be provided for the violation of rights. The law provides remedies as a means to enforce rights. The remedies provided for a breach of contract which violates the rights of a party to a contract are rescission of contract, suit for damages, suit for quantum merit, suit for specific performance of the contract, suit for injunction, and suit for rectification or cancellation of a contract. For rectification or cancellation of a contract. Rescission. When can a party rescind a contract? When one party breaks a contract, the other party may sue to treat the contract as rescinded and refuse further performance. He would then be relieved of all his obligation, but he has to restore the benefits received, if any, under the contract to the person from whom such benefit was received. Where he rescinds the contract rightfully, he can claim compensation for the damage suffered by him due to non-fulfillment of the contract. Rescission can be granted by the court when the contract is voidable by the plaintiff and where the contract is unlawful for causes which do not appear on the face of the agreement to be so, and the defendant is more to be blamed for that than the plaintiff. Rescission will not be granted by the court where the plaintiff ratified the contract or where the parties cannot be restored to the original position due to changed circumstances, or where a third party acquired rights in good faith for value, or where a part of the contract is sought to be rescinded and it cannot be severed from the rest of the contract. Damages. Damages is the monetary compensation awarded to the injured party for loss or damage suffered by him due to breach of contract. The object of awarding damages is restitution, that is, to place the injured party in the position in which he would have been if the contract was performed. The basis of awarding damages is to compensate him for the pecuniary loss which naturally arose from the breach of contract. The foundation of law of damages is the rule laid down in Hadley versus Baxendale. The facts of the case are: the plaintiff's mill was stopped by the breakdown of a shaft. He delivered the shaft to the defendant, a common carrier, to be taken to a manufacturer to copy it and make a new one. The plaintiff, however, did not inform the defendant that delay would result in loss of profits. By defendant's neglect, the delivery of the shaft was delayed for a long time and the mill was idle for a longer period. When the plaintiff claimed damages for loss of profit, the court held that the defendant was not liable for loss of profits during the period of delay because the defendant was not informed that delay in the delivery of shaft would cause loss of profits to the mill. The rule as laid down in this case was that when two parties enter into a contract which is broken by one of them, the other party has to be compensated through damages, and the damages which the other party has to receive should be such as may be fairly and reasonably be considered as arising naturally, or as may reasonably be in contemplation of both the parties at the time of making the contract as a probable result of breach. Section 73 of the Indian Contract Act deals with compensation for loss suffered due to breach of contract. It is based on rule in Hadley versus Baxendale. According to this section, when there is a breach of contract, the injured party is entitled to damages which naturally arose in the usual course of things from the breach, and to damages which the parties knew to be likely to result from breach at the time of entering into a contract. Remote or indirect loss caused due to breach will not be compensated. Rules governing the award of damages. 1. Damages arising naturally and directly from the breach, that is, ordinary damages, can be recovered. Damages which was in contemplation of the parties at the time of entering into a contract, that is, special damages can also be recovered. Exemplary damages, which are punitive in nature, cannot be recovered except in cases where there is a breach of promise to marry and where a check is dishonored by a banker wrongfully when there are sufficient funds in the account of the customer. Nominal damages can be awarded when the plaintiff has not suffered actual loss. Here, the damages are an acknowledgement that the plaintiff proved his case and won. Damages can be recovered for physical inconvenience and discomfort caused due to breach of contract. But damages cannot be recovered for loss of reputation except where a check is dishonored by a banker wrongfully. The injured party will not be allowed to claim the damages in full from the defendant if he has not taken reasonable steps to mitigate the loss consequent to the breach. The claim for damages for the loss that could have been mitigated by the plaintiff will be reduced from the damages awardable to him. Where the damages cannot be assessed, it cannot be recovered. But the fact that they are difficult to assess with certainty does not prevent the aggrieved party from recovering them. The court has to do its best to estimate the loss and provide some compensation. Costs for filing a suit for damages can be awarded at the discretion of the court. When the parties to a contract specify the amount to be paid in case of breach, or a stipulation by way of penalty for breach is specified in a contract, the injured party can receive from the party causing the breach a reasonable compensation not exceeding the amount so specified. What are liquidated damages and penalty? Liquidated damages is the sum fixed by the parties in a contract, which is a fair pre-estimate of the probable loss that might be suffered because of breach. Penalty is a sum named at the time of entering into a contract, which is not proportionate to the damage likely to occur from breach. While liquidated damages is a genuine pre-estimate of the loss likely to be suffered from breach, penalty is a payment stipulated in terrorem of the offending party, that is, to act as a threat against a party's intention to breach the contract. The courts of India allow only reasonable compensation. Now, what are the other remedies available for breach of contract? Quantum meruit is a right to sue where a contract is partly performed by one party and gets discharged by breach of contract of the other party. Here, the right is founded on an implied promise by the other party because of accepting the benefit of the part performance. Specific performance of contract. Here, the court directs the party responsible for breach to actually carry out the promise as per the terms of the contract, because damages are not an adequate remedy. Specific performance will not be granted when damages are an adequate remedy or when the contract is uncertain, unequitable, or can be revoked, or where the contract is made by trustees in breach of a trust, or where the contract is entered into by a company exceeding its powers as contained in Memorandum of Association, or where the court cannot supervise the execution of the contract. Injunction is another remedy that is available to prevent a party from doing something which it promises not to do. The grant of injunction is at the discretion of the court. Where the contract does not express the intention of the parties because of mutual mistake or fraud, suit can be filed for rectification of the contract. If rectification is not possible, the court will order for cancellation of the contract. However, this should not adversely affect the rights acquired by third party in good faith and for value. This is about the remedies that are available for a breach of contract. Rules pertaining to specific performance, rectification, and cancellation of contracts and injunctions are contained in the Specific Relief Act. Thank you.